The Bar Association has alleged that there was inadequate consultation prior to the passing of the Local Content Bill No. 21 of 2021 on Wednesday during the 34th sitting of Parliament at the Arthur Chung Conference Centre. Via a statement, the Bar Association claimed that a draft copy of the bill was not made available to them prior to its publication, as is usual the course for consideration and comment, same touching and concerning legal services. The Attorney General, Anil Nandlall, promptly refuted the allegation via an interview with the Department of Public Information, stating that, to the best of his knowledge, the Bar Association was the most consulted organization. He claimed that there were participants in a consultative process which was ongoing for several months. According to the Attorney General, he, Vice President Bharat Jagdeo, along with Minister of Finance Ashni Singh and Vikram Bharat, Minister of Natural Resources, were present at a consultation session of which a representative of the bar attended.
In a consultative engagement with a number of organizations, local organizations, I recall that the Bar Association had a representative at that engagement.
Senior Petroleum Coordinator of Ministry of Natural Resources Bobby Gosai Jr., in weighing on the issue, claimed that since a draft policy was presented in the National Assembly, the Bar Association has been actively engaged in consultations with the ministry. The ministry, he highlighted, received active responses in April, earlier in December, and the day before the most sitting of the National Assembly from the Bar Association.
Thereafter, the ministry engaged in strategic consultations with different bodies and associations and groups. The Bar Association was one of them. We have been engaging them since March, all the way up to yesterday, on the policy into the...
He noted that the issues raised by the association during consultations were primarily the same as those raised by other industry representative bodies.
That is in terms of the measurement of what capacity is available in the country and how we will capture that within the bill.
According to the Bar Association statement, during the Attorney General's debate in the National Assembly on Wednesday, the impression was given that Guyanese legal practitioners do not have the capacity or are not qualified to handle matters which they say the AG described as technical legal documents and joint venture agreements, as a seeming justification of 90% instead of the requested 100% by the Bar Association. The impression was given that persons who were not duly admitted to practice law in Guyana under the Legal Practitioners Act may do so, performing legal services.
To practice law before the courts of Guyana. That is to say you're the holder of an LEC and you come to Guyana, you get admitted, and you're allowed to practice law before Guyana. Equally, as a Guyanese attorney, I can take my LEC and I can go and practice law within Trinidad and Tobago.
Legal officer of the Ministry of Natural Resources, Michael Munro, who was a part of the program, however, noted that 90% of practitioners must be Guyanese attorneys of law admitted to practice law in the courts of Guyana, while the remaining 10% would have to be those persons who were not Guyanese, presumably. Nonetheless, they are eligible to practice law before the courts of Guyana. Reporting for HGP Nightly News, Alana Nadir.